Here's a story out of the Bay of Plenty Times in the last few days. Not a single district courtroom in this country has the facilities to host the trial for those charged after the Whakaari White Island eruption, a district court judges found. The trial for the 11 remaining defendants charged in relation to the deadly eruption will instead take place at the Environment Court in Auckland. That's 300 k's away from where the eruption took place. A district court judge, Evangelos Thomas, announced his decision to lawyers and a full public gallery at the Whakatane District Court recently. And he said ordinary justice should be done in the community in which events occurred. This factor strongly supports Whakatane, said the judge. But the other considerations are the large number of defendants, witnesses, members of the public, and local and international media who are interested in the story, and they just didn't have the room in Whakatane. And I guess White Island, and I can remember I was on here somewhere else the day it happened, White Island is almost the forgotten tragedy of New Zealand and those who lost their lives there, because then we had a whole lot of other stuff happen and there was COVID, and White Island became part of our history very quickly. I saw an interesting doco from the Sunday program about one of the people badly burned last night. But now we have the court action, which is essentially arising from whether or not people made the tourists safe enough. The legal action has been taken against White Island Tours. WorkSafe New Zealand is charging 11 parties with health and safety breaches, with the trial set to take place in the Environment Court, as we said, in Auckland. Well, joining us now is a Sydney-based lawyer who has been, but is not currently engaged in the case and legal matters surrounding the eruption. Rita Yousef is a senior associate and accredited specialist in personal injury law, and she did act on behalf of some of the Australian victims and their families during court proceedings last year. She joins us on the line, I'm presuming, from Sydney. Now, Rita, welcome to the platform. Thank you for joining us.
Good morning, Sean. Thanks for having me.
All right. Look, I'm really interested in this case because I think it speaks to how different New Zealand and New Zealand attitudes are, and just when something goes wrong in a situation like this, how complex, for a start, the legalities are in a country that has an ACC scheme and, to be honest, also has a reputation for putting its tourists in harm's way. Would that be fair to say it's a bit of a legal mess at the moment?
Yes, I do agree with that. It is a legal mess, mainly from my perspective because of the fact that New Zealand's compensation system is completely inadequate. And we've had a tragedy occur where people have been very badly injured, where their lives have been completely ruined, and the New Zealand system just doesn't cut it in terms of covering their losses.
And I guess it wasn't. Some might say, and defenders might say, it was never built for an incident like this. And it's built for people falling off ladders and stubbing their toe at work. And it's arguable whether or not it does that efficiently. What then do you do when you're working in a jurisdiction where that is the system for compensation, but for a client or for someone who's been injured, hurt, suffered loss or injury? How do you get outside the ACC system? How, as a lawyer, do you approach getting some justice for a client?
Well, in this situation, most of the people on White Island were part of a tour organised by Royal Caribbean Cruises. And so they had contracts with Royal Caribbean. Royal Caribbean held itself out to be the entity responsible for the tour. Most of the people on the tour wouldn't have had any idea who else was behind this tour. They just purchased their tour, bought their ticket from Royal Caribbean. Royal Caribbean says, meet here, we'll take you there on a boat.
Yeah,
you'll be doing this today, etc. So that, their position in terms of profiteering from this also means that they're responsible, and a lot of the victims have been able to pursue legal action against Royal Caribbean directly.
Yeah, and they're a big international or multinational firm, so they can't run and hide. They can't, fold up and disappear.
Yes, exactly.
Yeah. What about, though, Rita, when you go on a trip and it says you do this at your own risk? Because, there's the waiver thing, sign this, and you have to sign it before you go into the car wash these days. Doesn't that in some ways insulate the operators in Royal Caribbean if you say, well, I suppose no one reads the small print, do they? But is that ever an excuse in a circumstance like this, do you think?
Only in limited circumstances, in my view, where the risk is obvious, where any reasonable person in that position would be engaged in an activity and it would be blatantly obvious to them that it's dangerous and there are obvious risks arising out of it. But this is a situation where people have entrusted their safety in an organisation. People choose to do these tours not because they're volcanologists and they've done years of research on volcanic activity. There's an element of trust there, and with that comes a responsibility to protect safety and for the organisation to be on top of all the detail, to be on top of the unpredictability of it, to be on top of the risk warnings that had been issued by other entities saying that this...
having some sort of shelter on the island and an evacuation plan that was pre-planned.
Yeah, exactly, and protective gear. There are stories of some people only being issued with a mask. Some of the masks weren't even fitting properly. Just to have a shipping container, a tiny shipping container on the island for apparent shelter when most people couldn't even fit in there, and it wasn't an adequate shelter to begin with anyway. It just doesn't cut it when you're making so much money out of people and where you're lulling them into a false sense of security, where you're making it seem that you've done all the legwork for them and all they have to do is relax on this cruise and pay for the ticket and show up. Yeah. But actually, they haven't actually done the work to secure the safety, the safety of the participants.
The other thing, I guess, in New Zealand, and I think Australians have the same, perhaps not particularly appealing part of their culture. Take a cup of concrete, give it a crack, give it a whirl, she'll be right, don't worry, don't be a whinger. Of course it was dangerous, you should have known that, what were you doing there in the first place? And I don't think it works in this circumstance, because I put myself in the position of someone who would want to go there and didn't have intimate knowledge of the place. I would just presume that the risk was as low as it could be.
Yes, yeah, I agree with that. Especially when you're in a holiday mindset, you've been saving presumably for a while to go on this holiday. You're just thinking, I want to relax. I've paid this organisation to do the work for me. They've assured me that they want to do it for me because they've taken their money, my money. Yeah. So therefore, I don't have to worry. It's perfectly reasonable for someone to just go along and not have done the legwork themselves.
Yeah. WorkSafe taking the current 11 charges, the 11 cases remaining. You're not involved anymore. I take it your clients have reached settlement?
The short answer is I don't know about that. I haven't been involved so far this year. Yeah. In terms of timelines and when settlement or when compensation is paid out, it really does oftentimes depend on the individual, the level of their injuries. Yeah. In personal injury, we often talk about this concept of medical stability. So unless a person's injuries have reached medical stability, it's very difficult and basically impossible to finalise their claim, because their claim isn't just about what has happened to them to date. It's about their most likely future circumstances, and you can't get the medical evidence and the other evidence required for most likely future circumstances without their condition being stable. So for some people who've still been going through regular skin grafting, other procedures to look after horrific burns, for other people who've still been getting used to, say, prosthetics, big query as to whether their condition is stable and whether their claim could be finalised by now in any event.
Yeah. I must say the outcomes of pre-existing cases in New Zealand, I know there was a case, I think, against the National Emergency Management Agency. Those charges dismissed, and a tourism operator called Infinite pled guilty to a single charge laid under the Health and Safety and Work Act, and they got a fine of $227,000 and court costs of $40,000. It feels to me so long after the event that WorkSafe laying these charges is largely procedural, and I would question whether or not we get any structural change to the sort of problems with the ACC that you have identified on the show today. Is this just the system kind of rolling on slowly without focusing on some of the real concerns and changing the real concerns about what happened on White Island?
Yes, absolutely. The fundamental problem is that there is no compensation system based in negligence. And the result of that is, unfortunately, complacency. There's limited incentive for organisations to look after safety because there isn't that risk of being sued. They're not even needing to pay for public liability insurance because they know they can't be sued. That's a fundamental problem that needs to be fixed, I believe. And yes, there is the ACC, but there was a report just before on the news program about problems with the ACC. So that's just the tip of the iceberg. Barely covers anything. For somebody who's catastrophically injured, they're basically just being drip-fed some benefits. They're entitled to very, very limited lump sum compensation, and lump sum compensation is what allows people to get on with their lives. They don't want to be tied to a system having to seek approval
Report
for every little thing.
Tick the boxes, and those are general criticisms of ACC in any case. What would have happened, or what would have been different, had these events occurred in Australia, in the Australian market where you don't have ACC?
Well, these events, I guess, there would still be a cruise company involved, and we would, sue the cruise company for their involvement. But it would, so in New South, there's different legislation in each state and territory. In New South Wales, for example, there is legislation that says you basically can't sue, or you won't be able to successfully sue if you're injured as a result of an obvious risk arising from a dangerous recreational activity. So, in a basic sense, going on a volcano probably would be considered a dangerous recreational activity. But whether that's obvious, that's the key here. And there have been some cases recently in New South Wales that have shown that, what is obvious isn't actually that easy to prove. If you've gone on a tour, you've put your trust in another entity or another person, they've talked to you about wearing a mask and, wearing sturdy shoes and being ready to go for a walk, but haven't said anything about the fact that this thing might erupt and burn you alive. There's a strong argument that that's not an obvious risk, and that the injured person would be entitled to lump sum compensation covering their lost income, covering their treatment expenses, covering their pain and suffering, their care needs, equipment needs, and not just to date, but into the future.
Rita, are you an adventure tourist? I mean, do you do any of the bungee jumped or gone on a whitewater rafting trip or a jet boat trip or?
Yes, I have been on a jet boat trip in Queenstown, and I have skydived in Queenstown.
Oh, wow. Okay, so you're right up there, Rita.
Yes, and potentially a bit silly for doing that, but I don't know that I would do it again in New Zealand. But yes, I have done it.
That's what I was going to ask you. Given your experience in this case, what's your advice to people? And we've got a lot of adventure tourism here. We hope, I presume, to reinvigorate the industry. What would be your advice to people visiting New Zealand and taking part in these activities?
My advice would be to really think hard and to try as best as possible to do some of the legwork yourself. So when I went skydiving, I did think about, what are the risks here? Who's actually taking me on this skydiving trip? What kind of training will I be provided? What kind of risk management do they do? So they explained a lot to us about when they decide to just abort, even what we would think is a slight breeze would make them decide to abort. And so, just satisfy yourself that you're dealing with an operator who knows what they're doing, who's thoroughly experienced, who thinks about risk in terms of not wanting people to get injured and not taking stupid risks just to make money. Be absolutely sure that you're doing the right thing for yourself, because in the end, if you get injured, then fortunately you're not going to get much help.
Yeah. Well, I have no doubt this country and indeed the world will be watching this court case as it rolls out in Auckland. Rita, I thank you so much for giving us that background and that perspective as someone who has represented people who were tragically affected by that volcanic eruption on White Island. I thank you for your time.